Hello everyone. Again, I'm your Professor Robert Romano and welcome to Module 3, Civil Litigation and Alternative Dispute Resolutions. There'll be two parts to this section. There'll be two video parts. This is the first part and then I'm going to post the second part later today. So I need you to review both of them. First off, litigation. We spoke about it a little bit in the last module. Litigation is a process of bringing, maintaining, and defending against the lawsuit. Alright, just remember that. It was on the quiz last time, but it's the process of bringing, maintaining, and defending against the lawsuit. And also there are three things you need to realize. Litigation is time consuming. It takes a long time to get through the court system. It is expensive. Attorneys are not cheap. It is difficult to navigate through the complex procedural rules of the courts. Alright, like I said last time, each court has their own rules. Each courthouse has their own rules. So it's difficult to navigate through these complex procedural rules. Civil litigation, as opposed to criminal litigation. All right, civil litigation. Civil litigation is a body of state and federal law that pertains to a civil or private right that are enforced by civil actions. Okay. It's a body of state or federal law that pertains to private rights. Right? These rights are enforced by civil actions. They are non-criminal matters. Right? And they can be between just about any two parties. Individuals, one individual against another individual, organizations, businesses, government and its different agencies. So an individual can sue the government can sue an individual, two businesses can sue one another, and so forth. Some examples of civil litigation: breach of contract. Okay, two parties enter into a contract. One party breaches. They sue. That other party sues. That's considered civil litigation. Negligence cases. When I say negligence, I mean car accident cases, medical malpractice cases, stuff like that. Even defamation, to a certain extent, would be considered negligence. Employment law. All right. When you get out there and you're working for whatever fashion company or fashion house you're with, you have to know employment law. Know that when and how you can fire an employee or get rid of an employee. Okay, because that employee may turn around and sue you. And this is civil litigation. That suit would be considered civil litigation. Landlord-tenant issues. Right? If you have an apartment and your landlord, you're not paying the rent and the landlord goes to evict you, that's considered the civil litigation. And eminent domain, foreclosure, those are further examples of what is considered civil litigation. Non-criminal matters. And we talked about this a little bit, but civil law, the plaintiff is the person, group, organization that brings the lawsuit. Okay? The plaintiff brings the lawsuit. They are the ones that feel they have been wronged and need judicial intervention to correct this wrong. Okay? The plaintiff brings the case. The defendant, however, on the flip side, and conversely, is the person, group, organization that's being sued. Okay? They are the ones who have allegedly committed an act that the plaintiff feels is wrong. Remember, it's only allegedly up to this time. It hasn't been proven. Once you're sued doesn't mean you're guilty. It's only the first step in the process. Civil litigation, two concepts you need to be aware of. Number one is you need standing to sue. All right? You need to have a stake in the outcome of the lawsuit in order to bring the lawsuit. Right? If you don't have a stake in it, if you don't have any dealings with it, you cannot bring the lawsuit. Good example, let's say you and your landlord have a contract, you have a rental agreement between the two of you. The neighbor can't bring a lawsuit to get you out of there. Okay? They don't have any standing in the case. Only the landlord can sue to get you out of there. All right? The neighbor can't because the neighbor doesn't like you, you walk their dog in their grass, whatever. No, they don't have any standing to sue you for an eviction. All right? Same thing in a negligence case, car accident case. All right? You're driving down the road, you get hit by a drunk driver. the person in the car next to you can't sue. All right, because they can get hurt. They're not party to the case. Okay. Second thing is you need to realize in civil litigation, besides standing to sue, is a term called statute of limitations. All right. Think about what that means. Statute of limitations. Statute means law or codified law. Limitations mean, in a way, it's limited. So it's a law that limits what? It's a requirement that a lawsuit be filed within a certain period of time. So it's a statute that limits your time to bring a lawsuit. All right. It's a start date. Starts a date for that the plaintiff knew or should have known that the cause of action exists. All right. It's a start date. So let's say you get into a car accident today. You only have a period of time to bring that lawsuit. Usually 2 years from the date of the accident. All right. So you can't bring it 10 years down the road. You can't bring it 20 years down the road. No. The law is going to say you need to bring that case within a certain period of time. And in car accident cases, we're saying it's 2 years. Or 3 or whatever. But there's going to be a statute that limits the time you can bring your case. All right. Some examples, negligence cases, car accident cases, usually about 2 years. Breach of contract, usually about 6 years. Defamation, 3 years, and so forth. Each cause of action has a different statute that limits their time to bring the case. When you sue, you file certain paperwork with the court. And that paperwork is called pleadings. Okay? Those pleadings. And some examples of pleadings are your summons and complaint, your motion to dismiss, your request to revise, motion to strike. All right? These are known as pleadings. These are documents you file with the court. All right? Usually starts off with the summons and complaint, but then it moves forward from there, the answer, cross-complaint, intervention, and so forth. These are all pleadings. All right? So if I ask you on the quiz, give me 4 pleadings that can be filed within a state court. List summons and complaint, motion to dismiss, answer and cross-complaint. Bam, you get your points. Okay? The summons and complaint is the first document usually filed with the court. The complaint is a document that begins the lawsuit. It details the facts that the plaintiff believes justifies the claims and requests for damages. Okay? That's a document that spells out what happened. It provides enough information for the defendant to know why they are being sued. Okay? So it's a document, you file it with the court within that certain statute of limitations. Begins the case, details out the facts, and lets the defendant know why they're being sued. The summons is usually attached with the complaint. They go hand in hand. The summons and the complaint are now served after they're filed with the court. The court gives them back to the parties to serve on the defendant. All right? And the service needs to be done by a third party. Okay? It can't be done by the plaintiff's counsel. It can't be done by the plaintiff themselves. No, it needs to be served by an indifferent person. Or that person's a sheriff, marshal, or independent process server. But it cannot be served by the plaintiff themselves or plaintiff's counsel themselves. And the reason for this is it could lead to fraud. So you need to have an indifferent person do it, somebody who doesn't have a stake in the case, to serve it upon the defendant and then swear that they did it at a certain date and certain time. Okay? This notifies the defendant that he or she is being sued and amount of time they have to respond. Okay? Because once you get service, once you get that complaint served upon you, you usually have like 30 days to respond to it. All right? And then the plaintiff takes that service, that summons and complaint with the service record and sends that back to the court. So now the court has notice and they can start the time frame or the timeline. Next, once the defendant gets served, what they're probably going to do is file a motion to dismiss. All right. The next step would be the defendant's counsel is going to get it, going to review it. File a motion to dismiss. This case doesn't mean anything. Some of the other ones are requests to revise. The defendant counsel say, all right, we got your service, we got your summons and complaint, but we really don't know what it means. It's not clear enough for us, So revise it and make it clearer for us so we know what's going on. It's too vague. Or they're going to file a motion to strike it. It's similar to a motion to dismiss, but you can strike certain. Motion to dismiss usually dismisses the whole complaint. Motion to strike will usually strike a different portion of the complaint, like it's first one count of the complaint or one section of the complaint. We want to strike this part because it doesn't make any sense. The details of which you don't need to know. Then after all, the defendant goes through all those responsive pleadings, meaning the motion to dismiss, the request to revise, and the motion to strike, then the defendant will answer the complaint. Okay, the defendant will answer, and this usually takes 6, 8, 10 months, sometimes even a year before an answer is filed. Okay, because they're going to go through those responsive pleadings first. The motion to dismiss, the motion to strike, the motion to request to revise. And those take time. This is why I say litigation is very time consuming. And during this period of time, both attorneys are billing. So that makes it very expensive. Then the defendant will file their answer, and this indicates to the plaintiff and to the court why the defendant is not liable. Okay, I'm not liable for this, it's not my fault. And denies any allegations listed in the plaintiff's complaint. Okay, so now the answer is filed. Now this triggers the next part of the litigation process. If the defendant fails to answer, though, it'll result in a default judgment. The plaintiff will automatically win by default. All right, so the plaintiff, it's up to the defendant to make sure that the answer is submitted to the court within the certain time frames after all the responsive pleadings are filed, and get that answer in. If they never answer, it could lead to a default judgment, which means the plaintiff wins by default. All right. The defendant also can file a cross complaint. Well, after the answer is filed, they can file a cross complaint saying, no, we're not liable. You're liable. We were driving down the road. You hit us. We didn't hit you. You crossed over the center line. You were drunk. You whatever. It was your fault for the accident. This in turn means the defendant is actually suing the plaintiff in the same case. All right. The plaintiff then has to file the responsive pleadings and then ultimately file an answer, just like a regular defendant would. Okay. There's also another pleading called intervention. All right. This is when a party has standing in the case. They have an interest in the lawsuit, but they weren't named the party. So they can intervene on the case. All right. Let's say a car accident case, there's a plaintiff and a defendant. One plaintiff is a 3-car accident. All right, let's figure one car here hits the car in front of them, then hits the car in front of them. That's second, and then this first person sues the last person. The middle person was hurt too. They heard about the lawsuit. They can intervene on the case because they can get damages also. They become a party to the lawsuit. Okay? Then the second, after all the pleadings are done, this leads to the discovery phase. All right, so this is the second part of litigation. You have your pleadings. Now we're into discovery. And what this discovery means is this for both parties to discover the facts of the case. All right? Why courts allow discovery? It prevents surprises. All right, it allows parties to prepare, and it preserves evidence. So, this discovery process, which we'll go into a little bit more detail, allows both parties to discover certain facts of the case, right? And the courts allow it because it prevents surprise, allows parties to prepare, preserves evidence, and ultimately saves time because, again, the litigation process is extremely time-consuming. And also, I've noticed that once you find out more about your case, you're more prone to settle. All right, because the facts become more clear. Things start shaping out. Like, maybe my client is liable, or maybe my client isn't liable, So all this information becomes known to both parties. Nobody's hiding anything. A video may surface, and this will promote settlement between the parties. Some discovery, it's called depositions. All right, discovery. One part of discovery is called depositions. Second are interrogatories. Third are production of documents, and fourth are physical and mental exams. Okay. Depositions. I'll go through these one by one. Depositions. Basically, depositions are one attorney, let's say the defense counsel, subpoenas the plaintiff to come to their office at a certain date and time, and they sit there in front of a court reporter, and they ask the plaintiff questions about the accident or the breach of contract or whatever the cause of action is. And they do this to gather information, to find out see if the witness is credible, to see if the party is credible. So you, as a party, can be deposed or be subject to a deposition. All right. If you have certain facts relevant to the case, you can be deposed by either party. And again, you're called into an office. You sit there in front of a court reporter. You raise your right hand. You solemnly swear to tell the truth, the whole truth, and nothing but the truth. And you're asked questions for as long as both parties want to ask you questions. And you must answer truthfully because you're subject to perjury charges if you're found to lie. Okay? So those are depositions. Very similar to a courtroom outside of the courtroom. All right? The second one are interrogatories. Now, these are written questions that both parties send to each other. So the defense counsel may send 30 questions to plaintiff's counsel saying, I need to know your plaintiff's name, age, where they work, have they ever been in previous car accidents, have they had any previous lawsuits, in that kind of stuff. And these interrogatories are sent back and forth. And the party has to answer them, has to answer them truthfully, because they're swearing that they're answering them to the best of their knowledge. Okay, and usually there's a time frame. You have 30 days to answer, or 30 days to object to the question. Fourth is production of documents. Say you're in a car accident case, you're claiming medical damages, you hurt your neck, or your back, whatever it is. The other side has a right for you to produce those documents for them so that they can review them, actually. All right, so you have to produce, if you're making a certain claim, you have to produce documents to support your claim. You can't just say, oh, I hurt my back. No, there's no documents. No, if you hurt your back, you need to back that up and support with supporting documentation, and that supporting documentation needs to be turned over to the other side. All right, and the other side can ask you to go to a physical exam with their doctor. Let's say, you're claiming your back hurts, you got a 20% disability, and we don't believe you. You could be requested to go see the defendant's doctor, and so the defendant's doctor can make their evaluation. Okay? So this is all discovery. This is all facts becoming relevant, facts coming out, and it helps parties decide issues about the case, whether they should settle, and not be surprised. Okay? There, from the discovery, you move to pretrial. Pretrial, you file your pretrial motions for judgment, motions for summary judgment, settlement conferences. So before the trial even starts, you're going to file your certain motions. I want a motion for judgment because the defendant never answered the complaint. I want a motion for summary judgment because there are no facts at issue in dispute. So we win. Or you may say, let's try to go to a judge or an arbitrator and try to settle this outside of going to trial. So the court may say, okay, we'll grant you a settlement conference. Come in and talk to us on Friday. We'll try to settle this. Okay. And then you have the trial. Trials usually start with jury selection or voir dire. All right, jury selection. If you've ever been summoned to jury selection, you know how it works. If not, you are called into court to be there on a certain day. You sit there waiting to be called. You're called, and counsel for both sides have a time frame or a period of time where they can ask you questions. That's called voir dire. During this time, the juror needs to speak the truth. This doesn't mean you're selected for the jury. This is the period of time where the counsels are selecting who they want on the jury. Okay. Then, if you're impaneled, then you're required to sit for the trial. And an impaneled jury is usually about 6 to 12 people, depending on the type of case it is. So you go through the voir dire where you're asked questions, and it may be dismissed. You may say, nope, you can go, we don't want you. If not, you're impaneled, and then you have to sit for the trial and make a decision. You can be sequestered if you're selected during this period of time. And sequestered means you're outside of knowledge of the case. Okay? So you're not supposed to read any papers or watch the news, because you do not want to be influenced by outside sources as to what your decision is going to be in this case. Okay, so the court will say to you, I'm sequestering you. You are not to read newspapers, talk to anybody else about this case. You're not to visit the scene of the accident. You're not to watch the news. You are to listen to the facts presented to you in this courtroom and give a decision based on that, not from anything outside. Okay, newspapers, friends, anything like that. The trial. The trial starts with opening statements. Both parties may give a brief opening statement. During this period, they summarize the facts they intend to prove. All right, they have to prove them. All right, so if you know in the opening statement you can't prove this fact, it's a little sketchy. You might not want to get into that, because that may work against you. So both sides have a opening statement where they summarize the facts, summarize the legal issues, and what the client's claim is. All right, client has a valid claim, and this is what their claim is. Okay. Be aware, the plaintiff has the burden of proof. All right, in a civil action, plaintiff has the burden of proof. All right, and that proof is beyond preponderance of the evidence. In a civil action, the burden of proof on the plaintiff is to prove their case beyond the preponderance of the evidence. All right, if you put a number on it, it's like 51%. All right, you have to prove your case more likely than not, and you win. All right, this is different than in a criminal case where the burden of proof is beyond a reasonable doubt. In the criminal case, we'll take a second to talk about criminal for a minute. In a criminal case, the state needs to prove their case beyond a reasonable doubt. It means 99.9%. If the juror has any doubt in their mind that the defendant didn't do it, they need to acquit. All right. Whereas in a civil action, you can have doubt in your mind. The juror can say, yeah, more likely than not they did it. It's usually 51%. Beyond a reasonable doubt is 99.9%. And in the middle, there's another standard with regards to burden of proof, and that's clear and convincing evidence. And that's about 75%. Yeah, they probably did it. More likely than not they did it. Yeah, I'm pretty much convinced, but I got a little doubt. But all right. And clear and convincing evidence is used mostly in administrative hearings, in front of the IRS or OSHA or something like that. That's the burden standard used in those types of cases, clear and convincing. But in civil action, it's a lower standard. It's by a preponderance of the evidence. 51%. Yeah, I got doubt in my mind, but they probably did it. Okay. All right. It's the end of video 1. If you have any questions, comments, concerns, please feel free to reach out. If not, please move on to video 2, and we'll go from there. Thank you.